Friends and travelers, however you've arrived, I bid you welcome. Here at Let's Be Frank, we're about lives, and above all, living well. But I don't suppose a podcast hosted by Benjamin Franklin could be about anything else. In my lifetime, I pursued the practice of moral improvement like a science, recording my successes, and yes, oftentimes reveling in my failings. It's my hope, with our weekly almanac, to deliver to a curious world delicious morsels of history in quick, easy to digest installments, perfect for a sit in your favorite chair or a morning walk to work. At the end of each installment, I like to wrap it up in a neat little lesson you can apply to your own life, taken from the events, stories, and personalities shared in each episode. So sit back, relax, and together, let's make history.
Greetings and salutations, dear listener. Welcome to another installment of Let's Be Frank, an auditory almanac for the curious mind with me, your faithful friend and host, Dr. Benjamin Franklin, printer. Follow B. Franklin Live across our various social media platforms. B. Franklin Live on Instagram, TikTok, and YouTube. Let's Be Frank at Facebook. And if you wish to support the wit and wisdom of Let's Be Frank, consider becoming a member of our Patreon Junto. You can find the link in our show notes. Also support our producing partners, Primary Source Media. You can find them on YouTube by searching Primary Source Media. My friends, the world of 2024 only seems to get more historic. And indeed, my friends, we've had quite the historic week. But I wonder, my beloved Junto, what was my life like 250 years ago? That answer can be found in this week's edition of This Past Week, a Patreon exclusive piece of content where every week I visit what I was doing 250 years ago and bring it to life through a primary source. This week's edition of This Past Week features an account between myself and Lord Dartmouth, Secretary to the American Colonies, a document that I wrote 251 years ago today. Franklin's account in this letter of his interview with Lord Dartmouth indicates how little scope was left to either of them, 2 years before Lexington and Concord, to further reconciliation between Massachusetts and the mother country. Both the Englishman and the American wanted an end to the quarrel, yet neither could find a political solution that lay within the art of the possible. Governor Hutchinson of Massachusetts' debate with the General Court had brought the constitutional issue into the open in starkest form, and it could not be concealed by wishful thinking born of goodwill. I hoped, against hope, that Parliament would tacitly accept the principles that the court had enunciated. Dartmouth hoped, against hope, that the court would repudiate them. The first course was as unlikely in Westminster as the second was in Boston, and on both sides of the Atlantic, time was running out. 4 days after I wrote this account, the fateful Tea Act became law, and within 4 weeks the General Court launched the attack on the governor, based on his letters to Whately, that was intended to drive him from office. You can find the reading of my letter on our Patreon page. Now, with that out of the way, my beloved friends, let's get to today's installment. For purposes of good order, this podcast is composed of several primary sources associated with Ben Franklin's life, knit together to collect it all into one narrative on a cohesive theme. Today's installment is about the art of expression. It's about congressional bans, and it's about the most powerful court in the world. My beloved Junto, there has been something that has consistently crossed my desk with greater velocity through the various modern almanacs that I subscribe to, and that is the proposed congressional ban of the social media platform TikTok. For those who have not been following it, this is a brief summary according to AP News. The House passed legislation Saturday that would ban TikTok in the United States if the popular social media platform's China-based owner doesn't sell its stake within a year. The modified measure, passed by a 360 to 58 vote, now goes to the Senate after negotiations that lengthen the timeline for the company to sell to 9 months, with a possible additional 3 months if a sale is in progress. The bill's quick path through Congress is extraordinary because it targets one company and because Congress has taken a hands-off approach to tech regulations for decades. Lawmakers had failed to act despite the efforts to protect children online, safeguard users' privacy, and make companies more liable for content posted on their platforms, among other measures. But the TikTok ban reflects widespread concern for lawmakers about China. Now this humble printer is hardly informed enough about modern issues to take any great opinion, but I do have questions. Does the Congress of the United States have the best interest of the American people at heart? No doubt some possible tie is national security, but where are the limitations? Is the prohibition of a platform devoted to free expression an infringement on one's individual rights? How far will one go in the name of safety and security to preserve order, and will liberty be lost in the pursuit of it? And are equal precautions and measures being taken to corporations that are American-owned and American-run, as in this instance of Chinese ownership? And so I turned back to my own time to endeavor to find what parallels we could to discuss today not only congressional bans, but also how we walk that very thin slack line between the advancement of one's freedoms and the good order of society. Now, it might surprise you to know that in October of 1774, the first Congress of the United States put forward a ban on a certain form of expression that was not popular in the United States. One of the first actions the Congress of the United States took before we were even the fledgling United States. In October of 1774, the First Continental Congress passed the Articles of Association, which banned all trade with Britain until its grievances were met. Now, most of the articles had to do with promoting industry, wool, what goods we would or would not export or import. However, Article 8 put forward certain prohibitions that none saw coming and changed the way we expressed ourselves on the eve of revolution. Article 8 of the Continental Association says this: "We will, in our several stations, promote economy, frugality, and industry, and promote agriculture." So far, so good. "Arts and manufactures of this country, especially that of wool, and we will discountenance and discourage every species of extravagance and dissipation, especially all horse racing, all kinds of gaming, cockfighting, exhibitions of shows, plays, and all other expensive diversions and entertainments." Now you have to imagine, my beloved Junto, how artists, upon receiving this news, must have felt. Traveling bands of theatrical performers made their living in the colonies, touring their productions in repertoire. Imagine one of these roving troupes like the Douglases or the Hallams, the American Company, or the London Company of Comedians, arriving into a town only to find this posted bulletin. Almost overnight, theaters like the John Street Theater in New York, the Southwark Theater in Philadelphia, Church Street Theater in Charleston, all had to close their doors. Some companies fled the colonies, taking up residence in Bermuda or the Caribbean through the duration, so that they could continue their art away from the political strife and turmoil. When London received news of this theatrical ban, many playwrights put pen to paper to put forward their own sentiments regarding the ban. The following comes from James Rivington, who decried Congress's behavioral pronouncements as tyrannical and hypocritical, who made his sentiments of Congress known in his poor man's advice to his poor neighbors. "They'll ride in coach and chariot fine, and go to ball and play, when we've not wherewithal to dine, though we work hard all day. Rare sons of freedom, this Congress, so just as they think right, we are to eat, drink, frolic, and dress. Pray, masters, may we—" No, there's children listening, so I can't say the end of the couplet. In 1774, as a response, an English playwright in their work Zara would make equal emotional sanction against the Congress of the United States. In British once, it stains the historic page, freedom was vital struck by party rage. Cromwell, the fever, watched the knife supplied, she maddened by, and by suicide she died. Amidst the groans sank every liberal art which polished life or humanized the heart. Then sunk the stage, quelled by the bigot roar. Truth fled with sense, and Shakespeare charmed no more to soothe the times too much resembling those, and lull the care tired through this stage arose. Say then, ye Boston prudes, if prudes there err, is this a task unworthy of the fair? Shall form, decorum, piety refuse a call on beauty to conduct the muse? Perish the narrow thought, the slanderous tongue, where the heart's right, the action can't be wrong. Now that playwright would also take up his commission as Major General. Once blood was spilled at Lexington and Concord. He would cross the Atlantic to quell the rebel cause, and Gentleman Johnny Burgoyne would place a stepping stone for American independence for his historic surrender at Saratoga 3 years later. Our ability to express oneself, particularly to do so artfully, is a statement and reflection of the freedoms and liberties that we might enjoy. Indeed, it is one of the most essential tools to sustain a free state, the ability to express one's political opinions. With that has also come the various legal buffers that might be put in place to ensure that one's ability to speak or one's ability to write does not go far as to infringe upon the safety or concern of others. One may not issue slanderous or libel remarks without some frugal penalty of the law. Yet all the same, popular opinion oftentimes is a court in and of itself. When I returned from Great Britain, there was great suspicion as to my allegiances. Would I sign with the Parliament, having spent 10 years there while the dreaded Stamp Act and all the various policies leading to our independence were being debated on this side of the Atlantic? That suspicion of guilt was almost tantamount to the actuality and realization of it. The court of public opinion had already found me guilty. So I have no doubt, my beloved Junto, we see scattered throughout the American tapestry at this present moment, looking to this proposed Tik Tok ban, polarized opinions regarding support for it, regarding censure for it, and more than that, likely regarding simple censure for the Congress of the United States. We see a court of adjudicature spread throughout 50 provinces and encompassing the whole of a polarized continent. And so I thought, for today's installment, we would look back to a document that I wrote in 1789. A document entitled, An Account of the Supremest Court of Adjudicator for Pennsylvania, viz. The Court of the Press. It's a semi-satirical article speaking about the freedom of the press, specifically the freedom of the press to print whatsoever they wish, and how they may be held accountable. Listen to it, my beloved Junto, and we'll move to the lesson for today's installment. Power of this court. It may receive and promulgate accusations of all kinds against all persons and characters among the citizens of the state, and even against all inferior courts, and may judge, sentence, and condemn to infamy not only private individuals, but public bodies, etc., with or without inquiry or hearing at the court's discretion. In whose favor and for whose emoluments this court is established in favor of about 1 citizen in 500, who by education or practice in scribbling has acquired a tolerable style as to grammar and construction, so as to bear printing, or who is possessed of a press and a few types. This 500th part of the citizens have the privilege of accusing and abusing the other 499 parts at their pleasure, or they may hire out their pens and press to others for that purpose. Practice of the court. It is not governed by any rules of common courts of law. The accused is allowed no grand jury to judge of the truth of the accusation before it is publicly made, nor is the name of the accuser made known to him, nor has he an opportunity of confronting the witnesses against him, for they are kept in the dark as in the Spanish court of Inquisition, nor is there any petty jury of his peers sworn to try the truth of the charges. The proceedings are also sometimes so rapid that an honest good citizen may find himself suddenly and expectantly accused, and in the same morning judged and condemned, and sentence pronounced against him, that he is a rogue and a villain. Yet if an officer of this court receives the slightest check for misconduct in this office, he claims immediately the rights of a free citizen by the Constitution, and demands to know his accuser, to confront the witnesses, and to have a fair trial by a jury of his peers, the foundation of its authority. It is said to be founded on an article in the state constitution, which establishes the liberty of the press, a liberty which every Pennsylvanian would fight and die for, though few of us, I believe, have distinct ideas of its nature and extent. It seems indeed somewhat like the liberty of the press that felons have by common law of England before conviction, that is, to be either pressed to death or hanged. If by the liberty of the press were understood merely the liberty of discussing the propriety of public measures and political opinions, let us have as much of it as you please. But if it means the liberty of affronting, calumniating, and defaming one another, I, for my part, own myself willing to part with my share of it, when our legislature shall please so to alter the law, and shall cheerfully consent to exchange my liberty of abusing others for the privilege of not being abused myself, by whom this court is commissioned or constituted. It is not by any commission from the Supreme Executive Council, who might previously judge of the abilities, integrity, knowledge, etc. of the persons to be appointed to this great trust, of deciding upon the characters and good fame of the citizens, for this court is above that council, and may accuse, judge, and condemn at pleasure. Nor is it hereditary as in the court of dernier resort in the peerage of England, but any man who can procure pen, ink, and paper with a press and a huge pair of blacking balls may commissionate himself, and his court is immediately established in the plenary possession and exercise of its rights. For if you make the least complaint of the judge's conduct, he daubs his blacking balls in your face wherever he meets you, and besides tearing your private characters to slitters, marks you out for the odium of the public as an enemy to the liberty of the press. Of the natural support of these courts. Their support is founded in the depravity of such minds as have not been mended by religion nor improved by good education. There is a lust in man no charm can tame, of loudly publishing his neighbor's shame. Hence on eagle's wings immortal scandals fly, while virtuous actions are but born to die. Dryden. Whoever feels pain in hearing a good character of his neighbor will feel a pleasure in reverse, and of those whose despairing to rise into distinction by their virtues, and are happy if others can be depressed on a level which themselves, there are a number sufficient in every great town to maintain one of these courts by their subscription. A shrewd observer once said that in walking the streets in a slippery morning, one might see where the good-natured people live by the ashes thrown on the ice before their doors. Probably he would have formed a different conjecture of the temper of those whom he might find engaged in such a subscription. Of the checks proper to be established against the abuse of power in these courts, hitherto there are none. But since so much has been written and published on the federal constitution and necessity of checks in all parts of good government, it's been clearly and learnedly explained, I find myself so far enlightened as to suspect some check may be proper in this part also. But I've been at a loss to imagine any that might be construed an infringement of the sacred liberty of the press. At length, however, I think I have found one, that instead of diminishing general liberty, shall augment it, which is, by restoring to the people a species of liberty for which they have been deprived by our laws. I mean, the liberty of the cudgel. In the rude state of society prior to the existence of laws, if one man gave another ill language, the affronted person would return it by a box on the ear, and if repeated by a good drubbing, and this without offending against any law. But now the right of making such returns is denied, and they are punished as breaches of the peace, while the right of abusing seems to remain in full force, the laws made against it being rendered ineffectual by the liberty of the press. My proposal, then, is to leave the liberty of the press untouched, to be exercised in its full extent, force, and vigor, but to permit the liberty of the cudgel to go with it para passu. Thus, my fellow citizens, if an impudent writer attacks your reputation, dearer to you perhaps than your life, and puts his name to the charge, you may go to him as openly and break his head. And if he conceals himself behind the printer, and you can nevertheless discover who he is, you may, in like manner, waylay him in the night, attack him behind, and give him a good drubbing. If your adversary hire better writers than himself to abuse you the more effectually, You may hire brawny porters stronger than yourself to assist you in giving him a more effectual drubbing. Thus far goes my project. As to private resentment and retribution. But if the public should ever happen to be affronted as it ought to be with the conduct of such writers, I would not advise proceeding immediately to these extremities, but that we should, in moderation, content ourselves with tarring and feathering, and tossing them in a blanket. If, however, it should be thought that this proposal of mine may disturb the public peace, I would then humbly recommend to our legislatures to take up the consideration of both liberties, that of the press and that of the cudgel, and by an explicit law mark their extent and limits, and at the same time that they secure the person of a citizen from assaults, they would likewise provide for the security of his reputation. So what lesson can we derive from today's installment? If someone assaults your character, you assault them? No, my beloved Junto. I think there is something to be said for this court of public opinion, this court of the press. Every day we are the inheritors of new information, of new slanders, of new scandal. And indeed, if we are the judges and adjudicators of this court, these various pieces of evidence are brought before our humble bench. And so the lesson for today's installment, my beloved Junto, is that in the court of public opinion, be the fairest and best judge that you can. That's all for today's installment. Would that we had more hours in the day, but as always, we have nothing but time between us. Resource materials and images from this week's episode can be found in the journal section of bfranklinlive.com. If you like the show, subscribe and stay up to date with all the latest gossip, and do me the kindness of leaving a review. If you wish to support the wit and wisdom of Let's Be Frank, consider joining our Patreon, and lastly, my beloved friends, spread the word. Tell your friends, tell your family, tell your neighbors, tell your horse, I don't care. Let's make our intellectual Junto grow. And now, my dear friends, our time together has come to an end. Fare thee well. And always remember, when you are good to others, you are best to yourselves. Until we meet again, I remain your humble and obedient servant, Dr. Benjamin Franklin, Printer. Stay curious, my friends.